Freddie Perez.
Yes, sir.
Mr. Perez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On March 10th, 2025, officers initiated a traffic stop at 4841 block of Mount Houston Road in Harris County, Texas. Numerous vehicles were observed inside of a parking lot in a pit. The officer observed the defendant driving a white Honda, engaging in reckless driving by doing approximately 4 donuts. The defendant's vehicle was coming close to hitting people standing by the pit and other vehicles as well, disregarding the safety of the other people and their property. The defendant was the only occupant of the vehicle.
She's the only occupant.
Yes.
Okay, can you run his license, please?
Yes, Your Honor.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in a reckless manner again, not to do donuts, street takeovers, racing, any of this nature. If you do, first, I'm going to put you in jail. Next, I will take your ability to drive away from you. Do you understand?
Yes, sir.
It's valid, Your Honor.
All right. You're not allowed to drive unless you also have valid liability insurance in your name.
Here's what's fascinating about this reckless driving charge. Many people think of donuts or burnouts as harmless fun. But in legal terms, the judge sees it as reckless endangerment, a direct threat to public safety. Think about it. Perez wasn't just risking his own life. He was putting bystanders and property in the line of danger. The bond conditions laid out here are crystal clear. No racing, no donuts, no reckless stunts. The judge even threatens to revoke his license entirely. Audience, let's be real. Would a $500 fine and 30 days in jail stop you from trying this again? Or does the thrill always outweigh the risk?
That is a condition of your bond as well. So if you don't have car insurance, you're not allowed to drive. Do you have a lawyer today?
No, sir.
Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify. Do not leave until you sign our bond conditions. Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take your seat in the jury box. So,
Can I just say something? I want.
no. Don't. We'll talk later, please. Thank you. You are Catherine Olvera. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read and she consented to breath. The results were a 0.187 and a 0.185. She was identified by her driver's license.
So any prior WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olvera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. And he'll tell you if I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. All right.
Thank you, Judge.
Thanks, Mr. Nolan.
Yes, Judge. Miss Olivera Catherine with a K. Olivera. Arraignment.
Ms. Olvera, come up.
Yes, nothing more.
You are Catherine Olvera. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and she consented to breath. The results were a 0.187 and a 0.185. She was identified by her driver's license.
So any prior to WIs and then
No prior to WIs, her license is eligible.
got it. All right, Ms. Olivera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you're free to go. All right.
Thank you, Judge.
Thanks, Mr. Nolan.
That's great.
You said Kamisha Johnson?
Yes, is that how you pronounce your name?
Yes, sir.
Yes, yes, Kamisha
You're
Johnson.
appointed on the case?
Yes,
Put your paperwork right on the
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have.
This part right here might sound almost fatherly, but make no mistake. There's legal weight behind it. When the judge says, above all else, don't drive, he means it literally. Driving without a valid license or insurance isn't just breaking rules. It's stacking violations that could lead to harsher sentencing later. The judge even guides her toward contacting DPS directly, essentially saying, don't waste money, don't waste time, do it the right way. The frustration is clear. He's tired of seeing repeat mistakes that clog up the system. Audience, what do you think? Should judges play this advisory role or stick strictly to the law?
Don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, thing, could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 150 to,
I went there, that's why I have asked you.
don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Great. Thank you, Judge.
All right.
Ms. Johnson, Kamisha Johnson.
You said Kamisha Johnson?
Yes, is that how you pronounce your name?
Yes, sir.
Yes, yes, Kamisha
You're
Johnson.
appointed on the case?
Yes,
Put your paperwork right on the
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, thing, could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 150 to,
I went there, that's why I have asked you.
Don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you could go get your regular
Because
license?
on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Great. Thank you, Judge.
All right.
Good morning, Judge Fleischer. How are you doing? I have Jonathan Lopez on docket today. It's a violation of bond conditions. After speaking with him and looking at it, it looks like he signed for bond conditions on March 5th, and that was filed on March 5th, and that stated an address. However, another bond condition, an amended bond conditions, was filed on March 10th with that address crossed out and a new one added in. He wasn't aware of that, and that's the address that he went to for this violation of bond conditions. He's here.
If I needed to, this was a case
Yeah.
where we came back for a minute Moab. Brad was the attorney on it. We came in, we scratched out the old address. It looks like, based on what I saw, his client had initialed it, Brad had initialed it, and we sustained it. And it looks like as soon as he got out of jail, he went to that address.
He's not aware of those. Let me pull it up.
So you're saying he did?
Yes, Judge. On the amended book, there's his initials on the amended book, as well as the attorney.
I'll advise him. He was stating that he was unaware that that's why he was initialing. I told him I'll address it with him, but it's a presumption that he knows what he's signing. But I did tell him that I will bring it to your attention.
Does he want?
He's just basically saying that he didn't know what address that he was supposed to be prohibited from. He was under the impression that he's still supposed to be prohibited from the 20915 Bar Street and not Owens. I told him I would address it with you.
Okay.
We could bring him out if you want to.
I don't know. It's up to you. I mean, if you want to, but it looks like he's got a high bond on the felony case, huh?
Yeah.
And he's not made bond on that case, so he's got a high bond on our case as well.
Your Honor, I think that's actually, so there's two John Lopez on the docket. One's a DPO.
Oh,
Sorry, Your Honor. I know what case you're talking about too.
I see.
Oh, this one is just a misdemeanor. This
No. I have literally two Jonathan Lopez's.
Lopez's. Yes.
You're wrong.
I have Santos.
Your Honor.
That's why.
So this one, no, he just has this VPO. I did talk to the state. I understand the concerns. I just wanted to bring this to your attention because he's saying that he was unaware of the change of address.
I told him over and over and over. Can you bring him out? Jonathan Lopez? Santos. Here. Hold on, let me make sure you get the right one. Bottom of 38, yeah. If he tries to tell me that he didn't know. I mean, how many times did we say?
Well, this is the case where the plea was re-entered after the MOAB was amended, so then you advised him, admonished him once more.
Yeah, I told him I would bring it to your attention, Judge, so.
So this is the one where we did, we did the plea on the terroristic threat, right? The terroristic threat, the evading were dismissed. Two terroristic threats and an evading were dismissed, right?
That wasn't with me, Judge.
Yes, Judge.
Okay, so no, it was just one terroristic
One
threat.
terroristic
Yeah, it was
threat.
just one. How's jail? Some just don't get it. I mean, I'm truly at a loss. Truly at a loss. When we did the plea, not 6, 7 days ago, I told you probably 25 times, don't go back. And now here, you've picked up a violation of a bond condition of protective order. Let's do probable cause because I don't know. You have the right to remain silent. Anything you say can or will be used against you, sir. Please.
On March 12th, 2025 in Harris County, Texas, officers were dispatched to a violation of a protective order call. The officer met with the complainant who stated that she found the defendant in her mother's house while there was an active protective order, including a residency restriction. The officer arrived and found the defendant at the location and confirmed there was a protective order prohibiting the defendant from being at the location.
So it goes back to mom's house,
Yes, sir.
not the,
Yes, sir. She went back to the residence.
I don't know what we're gonna, I don't know,
I just want to make sure that he knows or that I wasn't there on the plea before. I just seen that the two different filings. He's saying that he didn't know the address.
problem is that we have
Yeah.
the wrong address.
Right.
So we
So,
amended,
but he was admonished about the new address.
and so far as the lawyer even went to the jail to go talk to him,
Okay.
to tell him. So I did,
Okay.
the lawyer did.
Okay. Well, thank you, Judge. I didn't know that.
I don't know if you're gonna get out, but let me tell you something, and I want to make this really clear to you, Mr. Lopez, is that now with what you were charged with, the Texas Constitution does not allow me but an extremely limited.
This is the turning point of the entire hearing. The judge lays it out with devastating clarity. Texas law allows for no bond if you violate a protective order. Translation: Lopez could be sitting in jail until trial, no way out. The judge isn't just frustrated, he's warning him that this is the end of the line. If someone still puts up bond, there will be an ankle monitor and zero tolerance. This is more than a lecture, it's a final warning before the system locks the door shut. Do you think some defendants only learn when their freedom is literally ripped away, or is even that not enough?
This being one of those, to have a hearing to hold you at no bond, zero bond. This is that type of offense. I don't know if you're gonna get out. I don't know if anyone is gonna pony up the $5,000 to get you out. If someone does, I'm going to put an ankle monitor on you. If I find that you violate any of the conditions that I'm gonna put on you now, I will have a hearing to hold you at no bond. Do you understand? I don't know what it's gonna take to get you to hear me, but perhaps that may be it. I don't want you to have any contact with the complaining witness in this case. I don't want you to have any contact with mom. I don't want you to have any contact with dad. I don't want you to have any weapons. I don't want you to go within 1,000 feet of where they live, or where they work, and the address listed in this order for protection. Do you understand?
Can I have the address, sir?
We will give it to you. Prior to me, I'm going to tell you this now, Ms. Strong, that prior to me accepting anything, any kind of plea bargain in this case, I would like to have a TRAS done to see how we go forward. Because I'm going to tell you now that every time that something, and,
I understand, Judge.
okay, all right.
Absolutely.
Okay, so we need him to sign conditions real quick, and then we'll give him a copy of the MOA right here, and then he can go back.
Thank you.
Sure, and I'm gonna find probable cause as well.
Okay.
Okay.
Hey, Judge, good morning.
Hey, good morning.
I have a case on docket today I emailed the prosecutors about. I just haven't gotten a response from them. So I saw Victoria's email and I thought I'd zoom on. I'm about to walk into court here in Brazos County. It's on Johnson. And I emailed Miss Watson, who I see is not there, but also I think Blaze was copied. It's just PTI documents showing that he's done everything.
So you're saying that this one's ready to go?
Yeah, it's ready to be dismissed.
Okay, who did you send it to? Did you send it to Blaze?
I sent it to Blaze and Mackenzie, but I know she's not there.
I got some later on.
Take your time.
Cool.
Yeah, he's being flanked every which way, so.
Yeah, no worries. I just want to be sure we weren't going to miss anything. So I appreciate it, Judge.
Yeah. Anyone else?
No, that's it. I just wanted to call and check
That's
in on
it.
that.
Okay, so just go. If there's a problem, I'll call you.
All right, cool.
You
Thanks,
don't
Judge.
have to wait just for the sake of waiting.
Okay, thank you.
Hello.
Do you know what your lawyer had worked out for you to do, sir?
Today?
No. What you were supposed to do between the last setting and today. What were you supposed to do?
They told me I needed to go to a mental health evaluation or something like that.
All you had to do was walk in, tell them that you're there to do it, and then they would have done the assessment.
Okay,
I don't understand why it never got done.
I would suggest not a reason, because he's gonna give you a week. That's my
yeah,
suggestion.
that's all I need. Okay, so,
Your case is 250 days old.
yes, sir.
Unacceptable that it's gotten this old.
I know, sir.
I will give you a week. If
Thank
you don't have it done in a week, I'm going to set your case for trial. And I'm not giving you any more resets.
Okay,
You'll be put to trial.
that's good enough, sir.
1 week.
Yes, sir.
If you
Yes,
don't
sir.
understand what to do, Mr. Newman can help you out.
That's why I have.
Just no more excuses.
Okay, yes, sir.
Thank you, sir.
Thank you so much.
Okay, sure. So,
I'm here today on Carl Lee Powell. He's in custody. It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation. And it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is like a roommate that he let a gentleman and this gentleman's girlfriend move in with him. And so
In her house.
in her house with the mom, with the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So,
Complaining and stated that Mr. Powell.
yes,
Okay.
assaulted her.
Okay.
And then charges were filed and he was given bond conditions. And at that time, like January 31st, a MOEP was signed. Okay. And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court. He goes back home. He goes back to felony court. The judge allowed him to amend the bond condition so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD. But the problem was the MOEP was still in place when he went back to the house. So I think it's a violate bond condition and a MOEP. But since that time, I guess, when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right? So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOEP as well, but the bond condition was removed after it was found the complainant no longer resided at
Still
the.
holding him at no bond too.
Right, so.
I don't understand how.
And then that's what I'm saying. He does go back to court on the 19th.
No,
for
I
the
mean,
felony.
with our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house, you just can't, I mean, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there. Because I think the idea is that they don't have communication together.
And I think the
Problem
date
is-
was the February.
And
Yeah.
what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
And according to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOA that wasn't amended, so,
No,
because that's, you know.
no, but they still are having contact.
Yes,
That's the problem.
Just as,
Not the fact that he's
just as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came,
And his mom is a complaining witness.
no,
Who's a complaining witness?
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the,
one guy.
yeah, one
So
guy.
that's Miss Scott.
Yes, yes.
Yes,
So that's Miss Scott's not.
not his
not-
mom.
not his
It's
mom.
not his mom.
Good, good.
So Miss Scott goes there to get her clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because somebody, it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm gonna find no probable cause.
We understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case. Howell.
And Judge, what we have, and just to be clear, the bond conditions were amended.
Yeah.
The MOA was not amended, and that's what this media is based on. Just to make sure that the facts are.
And then
clear.
according
There's
to,
two.
Was that an
different-
oversight on their part upstairs?
it appears
We
so.
don't know.
It may, probably was.
There's no note being way.
But these bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub though, they're holding him at no bond upstairs and then now for another 2 more days.
But the bond is removed. So,
I'm gonna find no PC. I mean, I can't,
This might be one I need to kind of go talk upstairs about.
do you want to email them real quick and see?
So
I mean, we haven't,
the DVD prosecutor did come down, and basically he was saying, you know, obviously it all depends on the felony, but he also indicated that the MOF was
If
still
he
in
had
place when the
place.
alleged.
Yes, Your Honor.
every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story then.
Yes,
That's
Your
the
Honor.
thing.
And so I,
Say that they amended the condition.
the other, sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So see, what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless,
Right.
Your Honor, before, I just asked for before
I'm not
a
going to.
decision is
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be
Okay.
there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet because obviously he's still doing whatever he wants to do. And I have concerns, you know. Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then,
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
Okay. yes.
Okay,
So
so we're gonna roll it to the 20th.
I would say, yeah, Thursday's the 20th so that we can,
Sounds
you
good.
know.
All right, thank you.
I mean, if it was after, I'd find no problem because all day. No,
All right, thank you.